So once again, welcome back to everyone, and welcome to this session. This is the interactive program on valuation under IBC, and I just requesting Dr. S.K. Gupta sir for welcoming to the our chief guest and opening remarks for this program.
Thank you.
Thank you very much, sir.
So good afternoon and welcome everyone to this interactive program on valuation under IBC being organized by ICMAI RBO in association with Insolvency and Bankruptcy Board of India. I heartily welcome the chief guest of this program, Sri Sankar Narayan, General Manager IBBI, all the panelists, learned faculty members and the panelists of this program, and all the participants for sparing their valuable time to be part of this very important program where we are going to talk about various dimensions of valuation under IBC. So we're going to talk about what are the expectations of RVs from IPs and vice versa. What are the expectations of IPs from RVs? What is the information that RVs require to be able to carry out credible valuations? How to go about and study and understand the valuation report? The challenges being faced by both insolvency professionals and the registered valuers in the whole process of valuation under IBC. As all of you understand, valuation is very, very critical for the efficient functioning of capital market, money market, the businesses, as well as under IBC. And valuation is the pivot around which all economic and financial decisions revolve. And that's more so in the context of IBC, because in the case of IBC, we are dealing with companies which are already in distress. Now, there could be two different kinds of companies. We could have a failing company which might be still viable, and there could be a failing company which is unviable. So if the valuation is not appropriate or if the valuation is not correct, it may so happen that a failing but viable company might get pushed into liquidation, or a failing and unviable company might be rescued. Both of these will be very, very unrequired or unconscionable economic outcomes to have in that situation. We want that those companies which are survivable should survive in the marketplace, and those companies which have nothing left in them, they should be pushed into liquidation. And the whole edifice of this entire process of CIRP and the decision to send a company into liquidation is based upon the ultimate calculation of estimate of value of the valuation of corporate debtors. So in this whole process, the resolution professionals, the bankers, the registered valuers and the regulators play a very, very important role. So what we have done today is we have got all the four stakeholders, rather five stakeholders together on one platform. We have RVO being represented by us. We have the regulator. We have a banker, Mr. Sanjeev Pandey, ex-Deputy General Manager from State Bank of India. He's going to bring in the banker's perspective to valuation. Then we have a whole lot of RVs and the IPs interacting jointly on this very important topic of valuation under IBC. So with these opening remarks, I would now request the chief guest of today's program, Sri Sankar Narayan sir, to kindly make some opening remarks before we start the program, sir. Over to you, sir. Thank you.
Thank you. Thank you so much, Guptaji. I'm very happy that this interactive program on valuation under IBC, you have also requested IBB to be part of it.
Yes.
And inviting me as a chief guest. I'm really honored. I'm really happy that our valuer organizations are doing such kind of programs, which is really the need of the hour and which is required under the stated valuation and valuation rules. Before I start, I think I was just going through the participants. I couldn't find any women folk. Today being International Women's Day, I thought I can
We have
greet
one
them.
women speaker with us, panelist.
Anyway,
Madam
congratulations to you, madam, to
Yes.
be part of the panel. Because if you see, out of the total 5,394 registered valuers which
Yes.
we are having, as per the December data, we 403 are women.
Wow. Okay.
So constituting only 10%.
Yes.
So
Okay.
that itself speaks. So I think out of the participants, that is the reason we are not finding any women folks.
Yes, please.
So
Yes.
my request is that we should start some sort of initiatives to grab women
Sure,
folk
sir.
also,
Sure, sir. Sure, sir.
because valuation, it is a more of subjective matter, and we can say art. So
Absolutely.
women can also contribute well
Sure,
on
sir.
this
Sure, sir.
platform. And second thing, what I wanted to say is, we have the demographics of valuers which we see. We find that less than 30 years old, we constitute only 6%.
Okay. Okay. Wow.
People are more than 40 years of age.
Mm.
So that constitute almost 68%, and 3,669 is the figure as
Okay.
per the data. So these are all some of the things which you have to take into
Yes, sir.
consideration
Yes.
while.
Sure, sir. Sure.
Now coming to the subject in question, as Taji was rightly speaking about, the purpose of IBC itself is that the viable unit should never be liquidated, and the unviable units should not be revived, in the sense that our good money is wasted on the bad asset, whatever it is already good, for which the importance of valuer is very, very important. So the purpose is that the valuation should be able to reveal the correct or the true worth of the assets which the valuer is valuing. If we do not get the true worth, see, we may be getting a price. See, the price may be very close to the value which you are providing. It may be higher, it may be lower also. But is that we are not bothered whether it is higher or less or whatever it is, but we are really bothered if two valuations are giving very, very wide disparities between the two. So the concern for the regulator is very, very honest, and it is very clear that when you are valuing an asset,
Yes, sir.
and
Yes.
if that same asset is having two distinct valuation, and that is not in close proximity, it is having a wide disparity between the two, it becomes very difficult for us to digest, because we receive a lot of complaints also on this count.
Yes, sir.
From different stakeholders. That is not in good interest. So that was the reason Gupta ji was also
Yes,
part
sir.
of the one of the first meetings which we had in IBBI, where we discussed about some sort of guideline or some sort of standard to be formulated for the benefit of the valuers, so that
Yes.
the disparities between these two valuation reports are minimized. So we all understand, because in the discussion has happened that valuation is subjective, and it is very difficult to get a close, or methodology, a specific methodology or any specific approach to get a particular desired value or whatever it is. So subjective matter we all understand, but our purpose is that we should bring more objectivity into that subjective matter. So that is possible only if we can set a certain guideline. That guideline can be in the form of what type of approach we can select for a particular class of asset, or what type of methodology which can be adopted for the specific type of asset within a particular class. It can be one or two type of methodologies for a particular type of asset, but ultimately the valuer should be very specific which type he is which methodology he is adopting, and what is going to be the result, and how he is deriving it. So that basis is very, very important in the sense that whenever you are giving the valuation, it should be justifiable. So if it is justifiable, nothing like that. So the purpose is that we want the valuation reports to be very transparent. We want the report to be unbiased, so that the stakeholders have wider acceptance, and there are no grievances either from the side of the stakeholders or from the side of the courts which they are considering these valuations, because we get some sort of adverse remarks from the NCLTs also, which is not in good interest. So maybe, but it is not very, very much, but at the same time, well, now we find that registered valuers, they know that they are under a regulatory regime, and they are also being properly educated by the registered valuers organizations in which they are enrolled. But at the same time, sometimes, some sort of lacuna is found. And IPs, especially, we find that we may have to again ask the IP to go for a training and all those things. But in case of registered valuers, much of actions are not being happening. And we are also somehow trying to sort it out at our level itself and close that complaints or grievances. So this is that is first objective. So this objectivity, we have to bring it into the subjective matter, for which we need some sort of guidelines. We can't depend always on the international valuation standards or the standards which are being set by some of the organizations. The standard, for which I request Guptaji also again,
Yes.
because
Yes.
you are highly qualified people under especially under the asset class of plant and machinery. So so these plant and machinery and land and buildings, I think your contribution will be very
Sure.
much required, because securities and financials, we can find even there was a talk that robotics will be able to
Yeah.
give valuation and for the securities and financial assets as such. Again, market capitalization, big data analysis. All those. The purpose is that we need a proper methodology which has to be given as a guidance to the registered values, so that the chances of erring is very, very limited. So as far as the regulator is concerned, we are drawing the power from companies' registered valuers and valuation rules that you all are aware. So we have to conduct the examination, registration of RBs and RBEs, we are doing it, and recognition of frontline regulators we are doing, and ultimately monitoring the valuers. But in all these things, we find that the role of RVOs are very, very high, in the sense that they are the frontline regulator, and as well as they are the people who are in the forefront of training the registered valuers and other participants in the valuation ecosystem. So then one of the expectations as a regulator, what I feel is that we should adhere to the code of conduct which is already provided in the rules. So that's important. And second thing, we should be able to maintain confidentiality, because in many of the valuation where the NCLT adverse remarks have come, it is regarding the close proximity of the resolution value to the liquidation value which is being provided. So stakeholders are keenly watching whether the valuer is maintaining confidentiality. So any infringement on that aspect is going to affect the profession. So that point I wanted to make it. And then, as I already told you, we should be transparent and unbiased, and we should do our work with integrity and give no room for any sort of bias. So for this, such kind of programs, and you should also have more, because our chairperson is now telling that we should have more of physical programs, because maybe it is a bit unviable for small organizations, but at the same time, it's all collective efforts. Like you can have a Google form and send to the valuers under your purview and ask them for a desired location. So how many will be participating? You will be able to get, and accordingly you can decide a good location. Like they will have a not only they will have a program of on valuation, plus they will have some sort of entertainment. That is also required because the problem is that, because highly tense situation is not at all required or envisaged as such. Then last point I wanted to make is that the country is poised for a 5 trillion economy and a developed country by 2047. So these two ambitions are in the book. And as far as this 5 trillion economy is concerned, $5 trillion economy is concerned, the services sector is going to contribute 3 trillion out of this 5 trillion. So 3 trillion is a very huge amount for the services sector, in which this valuation profession is also coming under. And when you talk about the $5 trillion economy, the assets under that particular $5 trillion economy is going to be almost 4.5 to 5 times assets which is going to be available. So the valuation professional scope in the near future, that in a couple of years, which is going to come in, when we are going to touch this $5 trillion, is going to be very good prospects for the valuers.
Yes, sir.
So with this note, I think I don't want to take much time. All the best to you. All the best
Thank
to all
you
the
so much, sir.
participants.
Thank you, sir.
So thank you so much. I may be leaving because in the sense
That's okay, sir.
in between.
Recording this program,
But
sir,
I'll keep this
get the
on
recording.
in the sense. Yeah. So any questions or anything, if you are having, you can always raise to us through the review. We are always welcome. Anyway, we will be meeting in monthly meetings also on
Sure,
13th.
sir.
We are
Thank you
meeting
so
it.
much. Thank you.
Thank you. Thank you so
Thank you,
much.
sir.
Thank you for
Thank you.
inviting us to be part of it.
Thank you, sir. Thank you.
Thank you, sir.
So I thank you, our chief guest, Shri Shankar Narayan, GM IBBI, sir. And now moving forward, I just calling our next faculty or the speaker, Miss Harmeet Kaurji. So I welcome madam to this session, and I requesting to you, please start your session, madam. Ma'am, I guess your mic is mute.
Sorry, is it better? Yeah.
Now it is fine.
Yes,
Yeah.
fine. It's fine
Thank
now.
you so
Thank you
very
so
much,
much.
Dr. S.K. Gupta. And
you.
it was pleasure listening to the views of IBBI, and special thanks to Mr. B. Shankar Narayanan ji. And you gave very valuable suggestions, and I can also understand from the perspective of an IP, I could relate to most of them because as a professional, those relate to us as well. And it is always a good opportunity to understand what IBBI requires us, in what manner we are required to, conduct our profession. And at the same time, while not taking much of your time today, because it is an interactive one, and I would invite if anyone has any point to you can surely interrupt me, because we are a small forum of maybe 20-25 people are there, and out of them I think 15 or 16 of them are hardly the participants, and I'm not a professional valuer, so I'm only an IP. So I'll be presenting my views on the special features of valuation under IBC, and not missing the opportunity again to congratulate each and every one of you, being Shivratri, and at the same time being the Women's Day.
Yes,
So,
please.
Greetings of the day to you. Greetings of the
thank
day
you
to
so
you.
very much, sir. And
Yeah,
that was
thank you.
actually an important number to note, that only 2% of the registered valuers are women. So
Not two,
area to be
10%.
worked upon.
10% are there, but of course it is a lower in number.
Yes, please. Okay,
Please
sure.
continue.
Yeah. So I
So
have
today, one more thing is that today is Shiva and Shakti both are coming together.
Yeah, yeah.
that is
So,
such a nice view, sir.
yeah.
Such a nice
Thank
view.
you. Yeah. Thank you so much.
So
Thank you.
I am not taking up the entire presentation of mine, considering that we have other speakers also, and they will be taking up the other parts of valuation, etc. Under other laws also, I'm not taking it up. I'm coming straight to the IBC, because that is the crux of the matter
Yes,
today,
please.
and the why and where the valuation is required under IBC. So, as Sir has already told, and Dr. Gupta has also highlighted, that valuation is one of the most important exercise under IBC, and the entire system revolves around it. We talk about resolving companies, we talk about liquidating them, but where is the crux? Where is the strength of the entire process? That lies in the money. So what money we are going to realize, what is the benchmark, what should be the threshold we should keep in mind, that comes out of the valuation exercise only. And therefore a lot depends upon the decision making, the opinions, the subjectivity, the analysis, the caliber of the valuers. And I must say that more than IPs are only executing their jobs, valuers are actually putting soul into it. So that is the base from where we start from under the valuation. And the current value of assets is to be analyzed, is to be determined, the assets which are to be ultimately liquidated. A critical element towards achieving the objectives is the transparent and credible determination of value of assets to facilitate proper comparison and informed decision making by the committee of creditors at the end of the process. This proves that the valuation is a core factor in achieving the objectives of the IBC in the resolution and liquidation. Why and how this is so important? Let me go through the points. Valuation report guides the actions of the IP, the COC, as well as the decision making by the NCLT at the end of the process. The fair and liquidation values are frequently used by IBBI for statistical purposes to gauge the performance of specifically the CIRP process. A registered valuer typically competes with market and endeavors to estimate a value which is more authentic than the actual price of that asset. The valuation report is a common cause of dispute for financial or operational creditors, and it may cause a delay in CIRP or the liquidation process. Any difference in facts between two valuation reports can be a trouble for the professionals working under that process. A few of the possible effects of under or overvaluation are, if it is undervalued, then there would be abnormal gain by the resolution applicant or the promoters of the company. There would be loss of realizable value for financial and operational creditors. There would be possible loss of reputation for the RV himself. Possible effects of overvaluation. There could be rejection of the plan which could have been approved and the company could have been revived. There could be delay in liquidation process due to requirement of a repeat process under the liquidation regulations because the CRP time period valuations are not reliable enough. So these are some of the possible problems which could come by slight deviation from the best possible methods and best possible outcomes of the valuation exercise. What are the methods? We are again restricting this to the scope of IBC. IBC recognizes several methods of valuation, important being the market-based approach, the income-based approach, and the cost-based approach. And I'm sure we don't need to get into the details of these methods because all of the valuers are knowing much more than me here. So I'm just reaching directly to what these terminologies and how they are defined under the CIRP regulations. So fair value is defined under the regulation 2 sub-regulation HB of CIRP regulation, and it says that estimated realizable value of the assets of the CD if they were to be exchanged on the insolvency commencement date between a willing buyer and a willing seller in an arm's length transaction after proper marketing and where the parties had acted knowledgeably, prudently, and without compulsion. So each and every word of this definition is important, and the valuers keep in mind this definition while calculating the fair value under the IBC. The liquidation value is defined under Regulation 2 Subregulation K, which says that estimated realizable value of the assets of the CD if the CD were to be liquidated on the insolvency commencement date. Therefore, under liquidation, it is the valuation where the seller is compelled to sell, wherein a reasonable period of time is given to a purchaser, but the seller is liquidated immediately on the ICD. So there are some elements missing over here without proper marketing, without proper knowledge, and with some element of compulsion. The said definition in its bare reading indicates that liquidation value is the notional realizable valuation of the CD's assets if the CD's assets were liquidated on the ICD and not the value that they may have realized under a resolution plan. Characteristically, an asset can have different value under different scenarios. What is realizable value? Realizable value has not been defined under IBC or its regulations or even under the standards. However, the general understanding of the realizable value is the value arrived after reducing the cost incurred to sell the assets from fair or liquidation value. The CRP regulations mention about the determination of fair and liquidation value of the corporate debtor, whereas the liquidation regulations mention about the determination of the realizable value of the assets or the businesses under various scenarios of sale. Both the fair and liquidation values under as defined under IBC, mentioned that it is the estimated realizable value of the assets. Therefore, the estimated realizable value of assets of the CD in case of fair value is considering a willing buyer and a willing seller and after proper marketing. Whereas the estimated realizable value of assets in case of liquidation is considering that the seller is compelled to sell given a reasonable marketing time, which is much lesser than the sufficient marketing time given under the CIRP. Therefore, the premise differentiates the fair and liquidation value. Quickly going through the IBC sections under IBC, regulations under CIRP regulations, and some regulations under liquidation regulations, which are related to the valuation. Now, IBC section 20 subsection 2 talks about the appointment of professionals. For the purpose of this section, the IRP shall have the authority to appoint accountants, legal, or other professionals as may be necessary. So, IRP has to appoint the valuers and not in line with the appointment of other professionals. It is very important to note that the IRP has the power to appoint the valuers and thereafter he needs to just get the cost ratified by the COC. It is not the similar process for the other professionals wherein he has to get the appointment approved. Here the appointment is not approved. He has to, as a duty, he has to appoint the valuer and only the cost is ratified by the COC. So there is an upper edge given to the valuer under this scheme. Section 25 subsection 2 talks the same about the RP. Now section 59 subsection 3 subsection B subsection 2. In case of the voluntary liquidation of the corporate persons, without prejudice to subsection 2, voluntary liquidation proceedings of a corporate person registered as a company shall meet the following conditions. Namely, the declaration under subclause A shall be accompanied with the following documents. Namely, a report of the valuation of the assets of the company if prepared by a registered valuer. Section 46 subsection 2 talks about the relevant period for avoidable transactions. The adjudicating authority may require an independent expert to assess the evidence relating to the value of transactions mentioned in this section. Now, CIRP regulations also talk about valuation and its relevance at various points. First two we have already covered. So I come straight to the definition of the registered valuer, which means a person registered as such in accordance with the Companies Act 2013 and rules made thereunder. Regulation 27 talks about the actual valuation under CIRP. The RP shall, within 7 days of his appointment, but not later than 47th day, appoint 2 registered valuers to determine the fair and liquidation value of the CD in accordance with the regulation, provided that the following persons shall not be appointed as the RVs, namely a relative of the resolution professional, a related party of the CD, an auditor of the CD at any time during the 5 years preceding the ICD, or a partner or director of the insolvency professional entity of which the RP is a partner or director. Regulation 35 talks about the fair and liquidation value shall be determined in the following manner. The 2 registered valuers appointed under Regulation 27 shall submit to the RP an estimate of fair and liquidation values computed in accordance with internationally accepted valuation standards after physical verification of the inventory and fixed assets of the CD. If the 2 estimates of a value are significantly different, or on receipt of a proposal to appoint a third registered valuer from the committee of creditors, the RP may appoint a third valuer for an asset class for submitting an estimate of the value computed in the manner provided in clause A. Subclause A of Regulation 35(1). So there are 2 scenarios when the third valuer may be appointed. One, if the valuation given by the existing 2 valuers are significantly different, and 2, if the COC decides as such. After receipt of resolution plans in accordance with the code, the RP shall provide fair and liquidation value to every member of the committee in electronic form on receiving an undertaking from the member to the effect that such member shall maintain confidentiality of the fair and liquidation values and shall not use such values to cause an undue gain or undue loss to itself or to any other person, and comply with the requirements under subsection 2 of section 29. So there are 3 requirements, prerequisites, only the completion and satisfactory completion of them, the RP shall provide the fair and liquidation values to the COC and not the complete report. So the regulations do not talk about the sharing of complete report, and only the values are to be shared with the COC, that too on completion of all the three conditions which are given in subregulation 2 of regulation 35. In cases not covered under subregulation 1 or where the liquidator is of the opinion that fresh valuation is required under the circumstances, he shall, now this is liquidation regulations. Liquidation regulations give a scenario where CIRP period valuation is not acceptable due to either there has been a lapse of time or the conditions have changed or the liquidator is of the opinion that fresh valuation is required. So he will record those circumstances and he shall within 7 days of the liquidation commencement date appoint 2 registered valuers to determine the realizable value of assets or businesses under clause A to F of regulation 32 of the CD. What are these A to F? I'm sure everyone is aware. Sale as a parcel, sale as a complete set. And E and F are very important. They belong to the sale as a going concern. Going concern as a business, going concern as a company. So provided that the following persons shall not be appointed as registered valuers, the same conditions apply here as well, which were applicable under the CIRP. So any related person cannot be appointed as a valuer. However, there has been a recent amendment in the IP regulations, which gives some liberty to appoint some of the related parties in case of an IPE. Let us understand what are those. Clause 23B, an explanation has been added, which says that for the purposes of this clause, the IP, which is an IPE, that means if an IPE is acting as an IP, it may engage or appoint its partners or directors for or in connection with any work related to any of its assignments other than the work related to valuation and audit. So here comes the importance that has been given to the work of valuation and audit. That has to be from an independent entity. That has to be a person who is not related to the CD or the RP in any manner whatsoever. A similar change has been brought in clause 23C. An explanation has been added for the purposes of this clause. The IP, which is an IPE, may provide any service other than the service related to valuation and audit for or in connection with an assignment which is being undertaken by any of its partners or directors. So here we understand that the auditor and the valuer of the CD in case of CRP as well as in the case of liquidation has to be a person independent under all these A to D clauses which have been given under regulation 35 as well as regulation 27 respectively. So the company's registered valuers and valuation rules, they talk about Sir Gupta sir. So just let me know where to stop because I have a long presentation and in case of
I think
time
you can
constraint.
take 5 minutes more, madam,
All right.
and then probably,
All right.
yeah, thank you.
So I'm only covering the provisions under law and the
Sure.
other slides I'm just skipping.
Thank you.
So the company's registered valuers and valuation rules were introduced in 2017. And the central government made rules for registered valuers thereunder. It enumerates the qualification, registration, and disqualification criteria for such valuers. These apply on the valuation in respect of any property, stocks, shares, debentures, securities, or goodwill, or any other assets or net worth of the company. It is hereby clarified that conduct of valuation under any other law than the Companies Act or these rules by any person shall not be affected by virtue of coming into effect of these rules. Asset class means a distinct group of assets such as land and building, machinery, equipment displaying similar characteristics that can be classified and requires separate set of valuers for valuation. Rule 8 of these rules talk about the conduct of valuation. The registered valuer shall, while conducting a valuation, comply with the valuation standards as notified or modified under Rule 8, provided that until the valuation standards are notified or modified by the central government, a valuer shall make valuation as per internationally accepted valuation standards, which were effective 31st January 2022, or valuation standards adopted by any registered valuers organization. So I think part B is still missing, and we are waiting and having a lot of expectations from this RVO as well, as the faith has been imbibed today by GM sir. The registered valuer may obtain inputs for his valuation report or get a separate valuation for an asset class conducted from any other registered valuer as well, in which case he shall fully disclose the details of the inputs and particulars, etc., of the other valuer in his report and the liabilities against the resultant valuation, irrespective of the nature of inputs or valuation by that other valuer, shall remain of the first mentioned valuer. So you can also use the report of the other valuer, provided that liability and responsibility for that valuation shall be yours. The valuation rules provide for notification of valuation standards based on the recommendation by the committee to advise, as may be constituted by the CG, which has not yet been issued. So, Rule 3 provides for the this is Rule 8. Sub-Rule 3 provides for the contents of the valuation report, valuation standards. This has already been discussed. ICAI valuation standards 2018 are also being used right now. So the members are advised to follow the ICAI valuation standards while conducting any type of valuation engagement to ensure uniformity and transparency. So this is mandatory for the members of ICAI RVO, I understand, and rest of the valuers are using the other standard, which are internationally acceptable standards. So am I correct in this?
Yes, please. Yes.
हाँ जी, ठीक है. तो I think rest of the I will share this presentation because this is quite a detailed presentation I prepared on the subject.
Sure,
And
madam.
I take your leave on the from here. I'll just stop sharing.
Thank you so much. Thank you.
And
So
thanking
thank you
you.
so much, ma'am.
Thank you everyone over here. May I request to switch on the cameras for once, please?
I'm just requesting to all the participants, please turn on your cameras.
Thank you so very much.
Thank you so much, madam. Thanks for your
So
delivery.
thank you so much,
Thank you
Harmeet,
for
for
having me here.
such a
Thank you.
wonderful session, madam, and nice presentation. So moving forward, our next faculty guest is our next speaker is Mr. Sumit Shukla ji. So Sumit Shukla ji, welcome to this session, sir, and very good afternoon.
So good afternoon, everyone, and
Very good afternoon, sir.
I sincerely thank the institute, the RVO, Gupta ji, and the board
Thank you, sir. Thank
for
you.
giving the opportunity to make my submissions with respect to my submissions so far as today's session is concerned. I'm sharing my screen. Is it visible?
Yes, sir, it is visible.
Yes, please. Yes.
All right. So as the topic suggests, it is an interactive program, and let us try and have discussions around whatever I'm going to discuss with you in next 20 to 40 minutes. So before we move forward, let's reinforce, because it is a reminder that we should have in front of us on day-to-day basis, so that we don't miss any of the parameters which I have tried to cover in one small paragraph. So I'm just reading this again to reinforce the overall purpose of this IBC regime. So IBC is a landmark enabling legislation that aims to provide a time-bound and efficient resolution of stressed companies. Purpose: to keep the ailing company as a going concern, to promote business and enterprise activities while maximizing the valuation of its assets under a governance model where affairs are managed by professionals in a highly regulated and automated environment under the instructions of the COC. Everybody knows that, and this is there is something which is there is something which is very repetitive that come across to us on day-to-day basis. Having said that, but still, as the insights being shared by the board, that many times it is the adjudicating authority, or many times it is the creditors itself, uh, and most of the times it is between RPs and RVs. They are continue to struggle while achieving these synergies between themselves. And once they are able to submit the valuation report, then it comes back with several queries. And this is why first we should try and understand the overall purpose of the IBC, so that whenever we have a question in front of us, or whenever we are dealing with a situation which is unique, since IBC itself suggests that we are going to deal with unique situations on day-to-day basis based upon certain sets of principles, and many times it is based upon the judicial pronouncements, whereas we are also witnessing that on daily basis we are seeing new regulations coming in, new interventions coming in from board, from the adjudicating authority, appellate authority, and honorable Supreme Court. The reason it is an ever evolving regime is because of the uniqueness of each and every case. There might be, or there will be situations which are going to uh, uh, appear as repetitive. However, there would be, and there are always certain situations which makes one specific assignment unique as compared to other assignments. Now we have understood that it is an enabling legislation, and whenever the authority is given to somebody, we all know that it comes along with the certain responsibility as well as accountabilities. And this is why possibly we are into this particular intervention, so as to figure out that the inconsistencies which are arising due to this particular process, wherein the RVs and RPs are going to work together, collaborate with each other to provide the stakeholders certain numbers which are going to provide the basis for the decision makers to take decision, including the adjudicating authority to decide the matters as and when they come up before them. Moving on to the next slide, that why we are dealing with the valuation and why we are putting up so much of efforts, and why it is becoming a talk of the town. It is simply because that the credibility of the decisions are going to test it at multiple places. For example, first of all, it is tested by the committee of creditors itself, since many parameters of any resolution amount or the distribution of proceeds under Section 53 are dependent on the valuation numbers, and the entire resolution plan or the distribution of proceeds is going to impact the stakeholders, most of the times in the form of haircuts, with certain exceptions. Therefore, the valuation reports, as and when being perused by the creditors and the stakeholders, they are going to have certain queries which are again coming back to the RPs and finally to the valuers. And in order to remain valuable to the entire or to the overall regime of IBC, it is important for us that as we get any opportunity in whatever capacity, be it valuer or be it the insolvency professionals, the decisions that we take, or I'm sorry that for using the term, both the parties are not have no powers to take any decision, but rather to support the overall process under the leadership, under the decision making powers of the creditors as well as adjudicating authority. So what I was trying to put across is that it becomes our duty to ensure that whatever the steps that we take during the course of an engagement, we must not forget that once the number are given, first of all, the numbers are required to be credible for both the parties, meaning RVs and RPs, so that their own professional credibility is not going to be questioned. That is one. Two, even if there is no doubt about the credibility of the professional, but the outcome of the valuation process is going to have a direct bearing on the overall decisions. Therefore, even if you are confident or the stakeholders are also confident that the numbers which are going to put across or which are going to be used as benchmark for various purposes in dealing with the resolution plan or with the liquidation process, those numbers are required to be precise. When I say precise, it cannot give a unique number, but it has to be directionally correct so that the decision is going to be taken in the right direction. And as Dr. Gupta said right at the beginning, that these numbers, I mean, the valuation reports are going to provide the way forward for a corporate debtor, that whether it should remain as a going concern or whether it should achieve its finality and move towards the liquidation and winding up process. And if at all, because of any reasons whatsoever, if this particular is if this particular process is not managed efficiently and effectively, then the entire ecosystem of IBC is going for a toss, since it is not only the RP and RV who are engaged with this particular matter, but also a lot of other professionals as well as the stakeholders, as well as the adjudicating authority, and so on and so forth. Thus, in summary, what I'm trying to submit is that whenever we deal with the valuation process, we must not forget that the outcome is not necessary. A logical conclusion is very much necessary. Logical conclusion as well as the timeliness. If at all we are able to achieve at a reasonable valuation, but we do not consider the timelines, then also this particular process is not going to make any difference whatsoever. I am taking a pause for a while, and I would request all the panelists as well as all the attendees to throw certain questions, because many times what happens, we interact over the we put across our challenges in the WhatsApp group, but we do not take the opportunity whenever we have this particular session, which is which is appropriately termed as interactive session. And if at all we are not going to interact, then either neither I am gaining nor you are going to gain anything. So therefore, I would once again request the panelists as well as other attendees to do raise your questions so that we could deliberate, we could discuss and figure out certain unique propositions which are not being used. And even if we are able to find out one or two such propositions, then I'm sure that the purpose of this session is going to achieve its purpose. So we don't have anything further to discuss. Nevertheless, I am moving on to my next slide. Another issue, or I would say another concern that we have to deal or that we come across on day-to-day basis is with respect to the appointment of registered valuers and coordination between these two professionals. Let us look at the challenges. We have a timeline of 47th day of the CIRP, as well as in liquidation also, we have to appoint the valuers, registered valuers. We have noted that almost on all the occasions, the timelines of appointment are met, but the valuation process does not move forward after the appointment. That is possibly one of the key bottlenecks or one of the key challenges that that is faced in most of the CIRPs. The key reason behind this is that RPs are having their own timelines, whereas the valuers are having their own assignments. While on one hand, the resolution professional would have less number of assignments, but slightly longer processes in their hands, whereas it is the other way around for the registered valuers. They would have more number of assignments, but the timelines would be shorter compared to the uh, to the uh, to the timelines that a resolution professional has. That is one. Two, there is a strict monitoring with respect to the timelines which are being taken by the insolvency professional, because a resolution professional or a liquidator is compelled to take steps in terms of in terms of calling the COC meeting, calling the meetings of the SCC. Then they have to carry out certain processes such as publication of Form G, preparation of RFRP, EOI terms, and so on. And at some point in time, most likely by 120th day, they are expected to provide the valuation reports to the stakeholders so that they can take the decision. However, after the appointment on or around 47th day, they are not having the visibility in the remaining period that what exactly is going on, and possibly there exactly is the problem that lies. And what what we have noticed that both the professionals are busy in their day-to-day affairs, and lack of interaction, lack of coordination, and lack of dependencies also on each other finally leads towards the delay in the submission of report. And once the timelines are coming under the pressure, then it is the impact that comes directly over the quality of the report. We all understand that if we have to complete the an assignment, and if we are not able to put up necessary time and effort, then the outcome of that process is going to be impacted, and the overall impact would be very much visible before the stakeholders. One important part is that we often miss that the stakeholders who are going to get the valuation numbers towards the end of the process, meaning just after the receipt of the resolution plan, they are going to challenge the valuation report on two counts. One, that they themselves had financed the money to the borrower. That is one. So they are well aware about the background of assets, because they have they were working with the corporate debtor very closely at some point in time. Two, the the outcome of the process is going to impact in the form of haircuts. And these haircuts are going to become vulnerable for them in order to take internal decision-making process with respect to the resolution plan. So what happens at one hand, we are dealing with the issue wherein the RP had issued the appointment letter, but because of so many reasons, generally it is the non-cooperation, he is unable to provide the data and the information which is necessary for the registered valuer. And when the timeline comes closes for submission of the report, then they started talking, and most of the time it is the assigning of reasons for the delay. So, rightly so, the RVs are expected to get the information and data in a timely manner, whereas the resolution professional may rightly point out that at the time of appointment letter, you should have highlighted the reasonable information which are mandatorily required. In addition to this, most of the time, the RPs also expect that the registered valuers are going to pursue the matter and try and ask for those information only which are very much available, since in almost all the matters it is the non-cooperation that creates the hurdle in terms of sharing information and records and data of the corporate debtor. So a balance between all these propositions or on all these parameters are going to have the impact uh, over the outcome of the process as well as outcome of the intervention of the registered valuers. Since the RP is conducting the COC meetings almost every month, therefore, they might be having certain updates given to the committee of creditors on a time-to-time basis. But on the other hand, the committee of creditors may not have the understanding about the challenges being faced by the registered valuers, which are practical and realistic, and those issues are also going to be resolved. And because of all these reasons put together, the relationship leads towards the friction, and everything put together is going to impact the process as well as delays in the CIRP. And as the process slips into the 200 after 180 days to 270th day, 330 days, and thereafter, the chances of other issues cropping up and delaying the process are also seen and experienced on almost all the occasions. Not necessarily they may be impacted on they may have any impact on the valuation, but for sure it is the litigation that takes place if a matter is dragged beyond a certain timelines. Therefore, what I'm trying to summarize is that uh, being professionals, uh, being subject matter experts, being having the access to expertise, when I try and deal with the registered valuers, they are subject matter expert, whereas the RPs are more closer to the stakeholders. So they should try and focus with respect to maintaining their relationship, one, in order to make sure that their interpersonal relationship should not become a reason for worry or a point of discussion in the COC meetings, wherein the COC is expected to discuss around the numbers in order to prevent more and more haircuts. And this is why possibly we are having such sessions wherein the expectation is to put on table all such issues which might get deliberated during such interactions. One person or one professional may share based upon his best practice, based upon his own experience, help support to formulate certain best practices that can be implemented as the standard guidelines, at least working guidelines for both the professionals. And this is why I would submit that handling an assignment is not so important, but managing the relationship in the best interest of the CIRP while ensuring the completion of the assignment in a timely manner, but also in an atmosphere wherein all the stakeholders are also getting the inputs in a transparent and timely manner. On the other hand, it is not the valuer who is suffering because of lack of data, lack of information, or lack of attention of the resolution professionals. Any questions or anything that we have to discuss on this stage at this stage? All right. Now let us look at the information which is required. We all know that valuation numbers are the benchmark. The fair value is a benchmark that supports the decision maker to decide, whereas the liquidation valuations are not only for decision making purposes but also for the compliance purposes. Compliances under section 32, under section 30 subsection 2, compliances under section 30 subsection 4, then comes section 53, and those regulations which are dependent on these three parameters falling under these three sections. Therefore, if at all the numbers are not directionally correct or the numbers does not reflect the realistic figures, knowing the lenders are having a very good visibility because of their association with the borrower right at the beginning, right at the time when the financial assistance was given, but also afterwards, since they are also obtaining the valuation from their own set of valuers. In addition to that, they have the market condition also, because under SARFAESI they are having the rights to auction the property as per the market rates, meaning whatever is being done in 120 days or 115 days between RB and RP, they are having at least directionally correct information with themselves. And the moment there is a deviation between their understanding vis-a-vis the numbers being put up by the RP, after obtaining it from the registered valuers, there are going to be discussions that takes the process towards the different direction altogether. And and sincerely, this is not the purpose for which the entire regime and uh, system of IBC, wherein several engagements are being done on day-to-day basis by the IPAs, by the RBOs, IBBI, and so on and so forth. Next is confidence over the regime, and this is something that we already had the insights that the moment number goes before adjudicating authority, then it becomes very, very difficult for us as advocates to discuss on these parameters, on because of the fact that numbers are confidential. We do not get the opportunity to speak at length compared to the matters which are concerning to RP or I or X management or any other section. On valuation, the advocates do not have much say, since first, this is a confidential information. Moreover, this information is coming from experts and then tested by the committee of creditors who have the commercial wisdom. So the moment the numbers does not match with the decision, as well as with the compliance requirement, as we just discussed, there are going to be questions which are going to be very, very difficult. And we all know once the questions are raised, then again, this process is going into a different direction, wherein at least 3 to 4 hearings are going to be faced by the councils just to calm the adjudicating authority, uh, which is being represented by not only the judicial member but also the technical members, and they are also coming from highly technical environment, and they have complete visibility. They have their own benchmarks, they have their own experiences, and therefore this particular coordination and lack of information and lack of uh, time and attention being given to the assignment is going to impact the overall process just because of this tiny or small reason. One strong submission, the valuer and the RPs must be fully aware about the situation, that if they do not provide the inputs in a timely manner, then definitely it is going to have the impact not only on the decision-making process, but also on the value erosion of the corporate debtor. Since uh, liquidation cost or CIRP cost is going to be first paid as and when there is a situation wherein the money is going to be distributed amongst stakeholders. So once the stakeholder realize that the valuation process is becoming a roadblock and eroding the value which is being left over to them after absorbing huge haircuts, they are not going to be happy with the process, and they would rather prefer to go ahead with their own surfacey actions and other mechanism that they have. Many times OTS also. We have been hearing a lot of cases wherein during liquidation also the bankers and promoters are getting into the 12-way discussions and OTS and so on. So there are certain best practices which I have submitted towards the best practices between the RVs and RPs, so as to ensure that their own relationship is not creating problems. Rather, it is the relationship that is adding overall value, and it is getting reflected in the overall results. So, few best practices and interpersonal relationship. It means that they should acknowledge and appreciate each other's challenges as well as each other's space also. They should not try and influence others' decision, because we know that this is against the very basic principle of law. Try and adopt best practices, because in handling the uniqueness of the cases, they should try and provide each other the guidance and support, because what happens, the valuers are coming from highly technical environment, and they are having more exposure towards the practical aspects of dealing with the assets, whereas the RPs are more conversant with the processes. Therefore, they should try and share these learnings and experiences with each other, so as to enrich each other's profile, and thus improving the overall outcome of the process and the intervention. Once again, the collaboration, I'm trying to emphasize that when the processes and rules are performed effectively and in a timely manner, most of the time we could assume that the results are going to be in the same direction in which the law has been enacted, as well as the expectations of stakeholders are also getting met. So from my side, this is what I submitted with respect to the topic which I have been assigned, and we can have further discussions, or maybe next panelist could also be requested.
Thank you so much, sir. Thank you so much, Sumit Shukla, sir, for such a nice presentation and the session, sir.
Most welcome, sir.
Thank you so much. So, moving forward to our next faculty or the speaker, I invite Mr. Vishnu Upadhyay, sir, for his views on expectations of IP from the RVs. Vishnu, sir, are you there, sir?
Yes, thank you. Thank you,
Sure,
sir.
sir. Welcome to this session, and please uh, start your session, sir.
Thank you. Very
Thank
good
you so
afternoon
much,
to
sir.
all of you. And sincere thanks to ICMI RVO for giving me an opportunity to share my views on the aspect of the expectation of IPs from RV. This is the topic for next 20 minutes. I can take 20 minutes or less.
You may take 20 minutes, sir.
Okay, thank you, sir. Thank you.
Thank you.
So the expectation as there are different stakeholders in the process and two major service providers to this process, ERP process, are insolvency professional who's handling this process as IRP or RP, and another is the registered valuer. So these are the key resources for this process, and IP appoint the RVs as per the regulations within 47 days. It is already mentioned by one of the panelist faculty. So after, at the time of appointment, the insolvency professional expect from the registered valuer that they must go through the scope of work, list of the assets which are need to be valued by the registered valuer, and they quote their they must quote in accordance with the scope of work. So that is the expectation, first expectation from the registered valuer by the IP, solvency professional who is handling the matter. So I do not, first let me clear, I do not have any such kind of presentation. I will make the deliberation as a discussion with all of you from the beginning of the process till the end of the process of the valuation assignment. So when the expression of interest is being given by the insolvency professional to the registered valuers, various registered valuers, based on their location, expertise, uh, or the knowledge about the industry, all. So the registered, it is expected by the IP that RV must go through with the corporate debtors. Detailed information is provided by the IP, and most of the time the balance sheet, the financial available with the IP is provided along with the expression of interest. So there are the different assets as per the balance sheet need to be valued. So based on the study of the balance sheet which is there with the registered valuer, the registered valuer need to estimate, need to make the estimate the quantum of work, their involvement uh, of the manpower. So based on that, they must provide the quotation, best quotation from their side. And it is also expected by IPs that it, if it is inclusive all, then it is more uh, appropriate to do the comparable with the other valuers. So that should be there. If any clarification required from the from the IP by the registered valuer about the assets or their location, involvement of the location, because based on the locations also the quantum of work will be vary. And also the involvement of the manpower of the registered valuer will vary. So it is required in the case of the valuation uh, on by the registered valuer from the IP, that they must, if any clarification required, that what are the locations involved for the purpose of valuation, inspection, physical verification, so they can ask. So if any query is there, they must ask the IP for that purpose. After submission of the quotations, the IP prepare the comparisons of the different valuers for different asset class and appoint the registered valuers for the different asset class. So after at the time of appointment, they issue the appointment letter. So when the appointment letter is issued, it is expected from the RV they must return a copy after accepting the appointment letter with different requirement also, like some declarations, disclosures. There may be requirement for the information to be shared with the RB. So the NDA may also require, sorry, NDA may also require by the IP. So they must provide the different requirement as required by the IP in time, because the IP has to make some compliances also with the IPA, like the detail of the professional appointed by the IP within 3 days. So sorry. So that purpose, the registered valuer must respond within the time, so the IP can make the compliances with the authorities in time. So that is the another expectation from the registered valuer. Then comes the list of requirement. The IP expect from the registered valuer that registered valuer must take the initiative and proactively, after accepting the appointment letter, he or she must provide a list of requirement for the purpose. Just a minute. So, RP can provide the required requisite data based on the list provided by the registered valuer. I used to call this list of the requisite data in short form LORD, list of requisite data. So that must be there in detailed form, that for each and individual assets, what are the requirement from the registered valuer is needed for the purpose of valuation. So insolvency professional can provide in time. So once the appointment letter is accepted by the registered valuer, the registered valuer must provide the list of requisite data to the resolution professional or interim resolution professional. So the team of RP or RP himself or herself can start working on the requisite data of the registered valuer in time, because it is there is a timeline for the purpose of completion of the assignment. The next expectation comes the coordination for the purpose of physical inspection of the assets. Once the data is received by the registered valuer must analyze the data received from the resolution professional. If it is not received, then he or she must follow up with the team of the RP or RP himself, and if required, he must make a call to the concerned person or the coordinating point at the site of the IP. Because there are many assignment with the IP, So there may be possibility that IP has designated someone for the purpose of coordination. So it is expected from the registered valuer that he or she or his teammate, his team member must coordinate with the coordinating point for the purpose of the receiving the requisite data in time. Sorry. Once it is received, the it is expected from the RV that he must he must provide the he must do his reconciliation that what is being received and what is left to yet to receive. So once the reconciliation is made and the analysis is being made by the registered valuer, so the RV should coordinate with the IP for the purpose of inspection of the assets in case there are the assets for the inspection, tangible assets are there. And in case of the valuer for the land and building and plant and machinery, there are the tangible assets. But in case of the financial assets, the tangible assets may not be necessarily available at the corporate debtor for the purpose of inspection. So accordingly, the registered valuer must discuss and align the inspection. Align the inspection of the assets of the corporate data. Once he align the inspection of the financial assets, the tangible assets, sorry, of the corporate debtor, he must do his inspection in time as per the time given by the insolvency professional for the purpose of the inspection. And after inspection, if he has some further requirement of the assets, the list of the requirement from the IP, he must share that list of requirement to the insolvency professional so he can provide. So this is up to the inspection and the further requirement of the documents from the resolution professional. After providing all the requisite data and inspection, the next expectation of the insolvency professional to submit the report in time. So it is expected from the registered valuer by the IP that he must provide his report in time to the resolution professional after covering all the assets in his or her scope of work. So scope of work is very clear with the different assets class. If any ambiguity or any clarification required from the insolvency professional, so proactively registered valuer must ask the RP for that purpose. If any clarification needed at any assets in his scope or not. And if it is being asked at the time of submission of the quotation, that is the great. If it is not, then later also it can be asked. And one thing which is expected from the registered valuer by the insolvency professional during the analysis of the data, if RV is having any idea of finding any new assets from the analysis of the assets, so the RV must disclose his that he found any new assets which was not there in the balance sheet. So how I will give one example for this, that sometimes the company pays some license fee, so the assets is there, but the expenses are booked as a operational expenses. and nothing is being booked in the balance sheet as an assets. So those licenses also are having the value with the corporate data. So those kind of things must be disclosed with the insolvency professional by the registered valuer. That these are the assets which we found, and these are not in the balance sheet. So you need to take the valuation for these assets. So this is expected from the RV by the insolvency professional. After submission of the report, then the IP goes through with the report. He reads the report as per his own requirement, and if he is having he is needing any clarification from the registered valuer, then that also need to be clarified by the registered valuer. That is expected by the insolvency professional from the registered valuer. Sorry. So after submission of the report, if any clarification needed, that must be clarified by the registered valuer in appropriate manner. If he is convinced and he sorry, he look for the further clarification, then also some expert advice also can be taken on the assets by the registered valuer, and that must be disclosed in his report. If any expert advice is being taken by the registered valuer for any purpose on the determination of the value, so that must be disclosed in his report. And it is expected by the insolvency professional from the registered valuer that report must be incomplete. That everything as per the reporting standard of the international valuation standard is being covered in the report. There are two standards, basically, the reporting and the scope of work. Those two standards cover what need to be considered as the part of the report. So that must be there in the report. It is expected that the report must be in a complete manner and timely manner. So these are the expectation from the registered valuer, so by the insolvency professional. And the independentness of the registered valuer must be taken care. Transparency, integrity, these are the code of conduct which also need to be taken care by the registered valuer when he is preparing his report. He need not to be in pressure by anybody else. If there is any pressure, so he should ignore that. He should not deviate from any standards of the valuations in his report. That is there from my side for the expectation from the registered valuer by the insolvency professional.
So thank you so much, Vishnu sir, for such a
Thank
nice and interactive session, sir. Thank you very much. And now moving forward, our next speaker is Mr. Sanjeev Pandey ji, ex-DGM SBI.
Can I ask a question, please?
Yes, sir. Sure, sir.
Okay. Yeah, just one small clarification. Thanks for the presentation, sir. Nice one. When a valuation is done, as you said, give the report. Is the RV also expected to give the Excel spreadsheets and the working to the IP?
No, it is not needed, sir. The worksheet is not needed, but those sheets, those working must be kept in his record. The basic annexures, like the calculations, the how he has derived the values, that must be there certainly as an annexure, but not detailed one certainly. And the approach adopted and method adopted and reasons for the approaches and assumptions being considered, any specific assumptions is been also considered for any estimation or any determination of the value for any assets. That also must be the part of the report from the registered value. It is expected.
Right. Thank you. Thanks.
Thank you so much, sir, for asking this question. And once again, thank you so much, Vishnu,
So
sir.
is
Now,
are we expected to even get confirmation from some redditor? Some IPs ask for the additional
So-
scope of.
No, sir, this is not part of the scope of the registered valuer for the confirmation from the trade receivables, right, sir? You are asking the trade receivables confirmation. This is the duty of the IP to take the confirmation. The RVs need not to interact with any other party for the purpose of valuation, in my opinion.
So in that
This-
case, we can exclude that from our scope and quote for.
Yes, sir. Yes, sir. Because I also have seen in my some expression of interest that you need to interact with the trade receivables for the confirmation or the reconciliations. So I straightway denied to do that. So because it is not my duty. If it is being required by the IP, he or she can appoint the other professional for that purpose.
Correct.
Yes, sir.
so once again, thank you so much, Vishnu, sir, for such a nice session. And now let's call upon our next speaker, Mr. Sanjeev Pandey, ex-DGM SBI, on the topic of valuation under IBC and bankers perspective. So Sanjeev, sir, you may just start your session, sir.
Yeah, thank you.
Welcome to this session, and you may start your session, sir. Thank you so much.
Thank you, sir. Thank you, Uptaji, and thank you, RVO, for inviting me to this August meeting. So valuation, as I understand, as a banker, so I have been associated with valuer since my early age when I started my career as a credit person in bank. So valuation is the start of the basic fundamental of a loan. And I'll tell you one reality which I realized after learning IBC and then my credit background, that IBC, the CRP process starts with a default, right? And where the default starts, or rather I would say the root cause of default, or I would say strategic default, is valuation. So this I learned the hard way. Sometimes when if you see most of the parties going to a bank seeking a loan, so bank generally ask for a valuation of the primary and the collateral securities. So this has been a common practice that you get a good valuation of your asset and get on the basis of that you get a higher limit from the bank. And when it goes to, and then there lies the root cause of the default. Once some person, some unscrupulous borrower, he has taken a borrowing or a loan which is valued higher than the value of underlying assets, whether it is a collateral or a primary asset, this loan is bound to default. This borrower is bound to default. It is only a matter of time, and these defaults I call strategic defaults. So as valuers, we should be very, very conscious of valuing not only inside IBC, even outside IBC, because we may be getting, as I think GM IBBA also indicated, that this valuation profession is going to be a huge profession. We have a scope of 4 to 5 times the size of economy, which is potential of 5 trillion economy very soon. So the size of valuation market would be something like 20-25 trillion. So we should be very conscious of what value we arrive at, because that will decide the ultimate fate of a particular loan, or even the fate of banks. So that is one thing I would like to share as a banker. Then second important aspect of valuation, because as we know under a CRP, the valuation report is shared with the COC at the fag end when the plans are in place, plans are received. And just before presenting the plan, the RP shares the valuation report, of course, under a non-disclosure agreement with the COC. At that time, the bankers have an opportunity to look at the report first time. And as a part of many COCs, as I headed the NCLT division of SBI, so it used to come as a surprise, because based on our assessment, sometimes the valuation would be very low or sometimes would be very high. Both cases, it leads to problems. If it is too low, as GM also said, Mr. Gupta also highlighted in his initial address, then you are putting a bad asset for rescue and you are pushing a good asset, a viable asset to liquidation. So to avoid that kind of result, I think the reasonable and a professional valuation is very, very important. The liquidation value arrived in the plan and the fair value. When it is disclosed to the COC, I will tell you most of the banks, they look at liquidation value when they look at the resolution plan. And as we have observed in many cases, many times resolution plan amount is less than the liquidation value. And still, despite the Supreme Court clarifying that this liquidation value purpose is not for approving the plan, there is no relation between liquidation value and a resolution plan value, and a plan below liquidation value can also be approved. That is the clarity given by the court. But I'll tell you, most of the banks still follow the thumb rule that anything below liquidation value should be taken to liquidation. So we should be very, very conscious of putting a liquidation value which may be higher than what you actually get in the market. Because what is a plan value? Ultimately, plan value is something which a potential resolution applicant is putting on the CD. And he is actually not only putting that value, he is buying a second-hand asset, he is buying a stress asset. So whatever value he assigns to that particular asset or CD, he will put a discount on that, depending on the quality of the IM, quality of information available. So you should also be conscious whenever you arrive at a liquidation value. Of course, you are bound by standards. At the same time, I have seen many cases like the remote land where the unit was situated, the land was valued very high. And we have seen in bank that these industrial lands lying in remote areas hardly find any buyers. So if we put too much value on the land, that is the plan is non-starter, and the unit will ultimately go to liquidation. And even under liquidation, it's very difficult to sell the land because the valuation is very high. So that is one purpose of plan approval. So if your liquidation value is the basis of plan approval by most of the COCs, so your value should be very, very critical and very analytical and professional. Then comes to interim finance. Most of the RPs struggle to get interim finance from COCs or outside COC lenders because COC doesn't allow. The fundamental of interim finance is valuation. Ultimately, why interim finance is required? Because interim finance leads to preservation of value of a CD. So whatever value you arrive at the start of CRP, if that value is to be maintained, then some expenditure on the maintenance, running of the going concern, status of the company, and all other things require some funding. But when the proposal goes to a bank to sanction an interim finance, what he will look at is, okay, how would I recover this money? If I pay interim finance today, if I lend this, how would I recover after say 12 months when the process is over? How do I recover when we don't get a plan and company lands into liquidation? Or how do I recover if the CRP is delayed by almost say 2 years due to litigation? These are all the questions. But ultimate justification of interim finance will come when the valuer is able to justify, or the RP is able to justify on the basis of valuation report that, sir, this is the value today. If you don't give us the interim finance, the value will go down by this amount. And if you give us the finance, the value will be maintained or maybe upgraded by this amount. So that may require your support to the RP. So that is also a very critical area where I think your intervention may be useful for the resolution process. Then I think most of the evaluation report, of course, you do a professional job. You base it on the international standards, accounting standards and valuation standards. One thing I see as a practical banker and a practical now professional also in the IBC space, that whenever you go and try to sell the asset in the market, the counterparty, the potential RA is looking at a certain value proposition in this company. He's not looking at overall value. He knows what is the value, maybe approximate value of the land and what is the machinery. Ultimately, he is looking at a USP, which I think you should somewhere highlight in the report. Okay, ultimately, this is the valuation, but there is something like the brand of the company, or maybe the goodwill, or some product, or some intellectual property right. There some value lies. So this also maybe it will be a good idea to highlight that. Another challenge the bankers feel when the unit goes to IBC and the valuation report is shared with the COC, that it is diverging dramatically from the valuation taken by the bankers originally when the loan was sanctioned, or maybe subsequently. So I would suggest that whenever you start the valuation process, you are assigned the job of valuation, seek the support of RP to get the valuation reports from the banks, old valuation reports, so that they will help you in assessing how the valuation was done initially, and give you some idea of the background of the unit. And ultimately, this confidentiality of the valuation is, I think, good idea. But at the same time, it also leads to some delay in sharing of the valuation report with the COC, which, as a person, I feel is counterproductive.
ऊपर
So
वो लैपटॉप रखा है उसको बंद कराना ऐसे कराना ना अभी दोबारा है
please put yourself on mute, please. Yeah. So I think this is a two-sided sword, where one side, well, the confidentiality of the valuation, maybe it is assisting the COC or the RP not disclosing the value to the ultimate.
May I add only one thing to what you said on the indication of a brand value and other things in the valuation report. I feel it should be more appropriate. It should be disclosed in the IM by the IP, rather than in the whatever
again,
assets we can value only, we can mention in the report, and also what we find in the balance sheet.
So that is, I think, a good suggestion for IBBI to adopt for the intangible assets or these kind of assets. Maybe they should allow that RP should get a valuation and then disclose it in the IM. So that can be, I think, one suggestion from the RP.
That is the intrinsic value attached to the company.
Yeah.
But I also find that in most of the cases, that is not captured. So what happens is you get a haircut more than what you deserve.
Yes. And lastly, just because I am also finishing, my timeline is over.
Yes, good.
So I would only say that we approach IBBI with this idea of removing this confidentiality, because ultimately somehow the valuation figures goes to the market from whatever source. So what we suggest is that once they may try to have it disclosed upfront, so that the everybody is aware of the valuation, and if there is some issue in the COC with the valuation, they can call the valuer upfront and discuss with him and understand, and maybe share their ideas, which never happens till the late stage when plan is already in hand and everybody is rushing into the approval of the plan. I think recently IBBI has changed some regulations where they have allowed the valuer to share their methodology with the COC. But my personal view is that even sharing of valuation with COC is better idea, because then they know upfront what kind of value we are going to receive, and even what valuation is being done. If there is any problem with the valuation, they can already negotiate with or discuss with the valuer at that stage. That's all I have to say. Thank you very much. Thank you for patiently listening. Any questions? I'm ready to take them.
Thank you so much, sir, for your very practical deliberations. Thank you so much for your time and very useful suggestions made by you. Thank you so much.
Thank you so much, sir.
We would now like to invite Mr. Harshad Deshpande. He is the Central Council member of the Institute of Cost Accountants of India and also director on the governing board of ICMEI RBO. Shri Harshad Pandey, sir.
Harsha ji is joining within 2 minutes. So we'll start the session within 2 minutes.
Fine, we can wait for 2 minutes.
Sure, sir.
Let him join. Yeah.
Sure, sir. So this is the announcement related to the CPR claiming. So I just request to all the participants to claim the CPRs as a RV or the IP. I just request to all the participants, please mark your name and your email ID along with your IBBI registration number in the chat box, so you can get the CP credits. So I guess Harshad sir have already joined us. So good evening, sir, and welcome to this session. Harshad sir, your voice is not audible, sir. I guess your mic is mute.
Yes, sir.
So welcome to this session, sir. And
Thank you, sir.
I just requesting you to please start your session. The topic would be expectations of RV from IPs. Thank you so much.
Expectations.
Sir, expectations of RVs from IPs.
Okay. So from IP perspective, what are the
Yes.
expectations from the valuers?
Right, sir.
So thank you very much
Thank you so much.
for giving me this opportunity. So perhaps I'm sitting on the both sides of the table sometime. I'm also registered valuer as well as insolvency professional. So when I work as a registered valuer, what is the expectations, rather what the insolvency professional wants a registered valuer to do. This is perhaps the topic we will discuss. Okay. So understand that from the insolvency the professionals.
Harshad ji, I think the topic given is what is the expectations of RVs from IP? In fact, what documents are just I think you can go through. Expectations of registered valuers from insolvency, if I am right.
Yes, sir. Absolutely. Topic is
sorry to intervene. In fact, either way you can discuss because both are really fruitful. I thought I should just.
Sure, sir.
So let us first talk about that aspect also. That what a registered valuer expects from the insolvency professional. Since we will be doing the assignments as a valuers, okay. So generally, when it comes to the valuations under IBC, okay. Now the real challenge about the valuation under IBC remains the data, okay. So you will find that invariably this IBC, if suppose somebody approaches you for valuation, and you have to carry out a valuation. So the first and foremost things that any valuer would like to have is the have the financials, latest available financials in place, or books of accounts, or uh, in whatever manner you called information which will help the valuer to evaluate the financial position of the corporate data. So it starts from that point itself, because many times you will find that these accounts of the corporate data are not available. Rather, it's not available with the IP also, because sometimes it happens that this uh, uh, balance sheets and these are not being prepared. These are many times not being filed. So even if they are prepared, it may be with some auditor or this thing, and there could be some points of differences between the corporate data management and auditor. So the first point, and also it's very important to know that this information uh, generally it is not available with the IPs. Okay, because you see, as insolvency professional, when I see that in 50%, rather more than 50% cases, you will find that latest available financials or audited financials are generally not available. So this becomes a first hurdle that perhaps the IP has to pass through and provide the necessary documents. Rather, the first would be the financials. So many times what happens is that there are financials which are available, which may be 3 years back or 2 years back, or sometimes it's more than that. So in that case, that becomes a first and foremost challenge to the valuer, because a valuer, we are going to value the CD. Uh, when we are doing at the time of CRP, it will be at the commencement date of the insolvency, uh, uh, rather the CRP date, we call it as commencement of insolvency proceedings. And in case of a liquidation, it will be the liquidation commencement date. So either CRP date or LCD date will be a cutoff point wherein we have to carry out the valuations, and we will require financials as on that date. So that point perhaps is the starting point. Thereafter, you will see that once you suppose some of the data might have prepared, or many times it takes some time to IP to collect the information and give it to you. So he might complete the accounting, or he may collect some data from the different sources, and he will give it to you. So in between also there is a time gap. So what happens is that even if you have got assignment, and the you receive a financials maybe after 1 month or 2 months of time, so that cuts down your time available to complete the valuation exercise, because the valuation is very critical for the CRP, especially when the plans are uh, uh, these are available, or these plans are put to the COC. So the timeline wise, you will see that the time gets shortened if that information is not available. Then even if you got a financials, the next challenge for a valuer is that to get the necessary documents. Okay, so I am a SFA valuer. So if I look at the major categories of the assets wherein the valuations are perhaps, or the main thing are there. So it comes to the assets like, intangible assets. It comes to the loans and advances given. It comes to the trade receivables. It comes to the cash equivalents. It comes to the current investments. It could be the other current assets like the liabilities, rather this taxation authorities deposits. Then other deposits with the different government agencies, may it be the taxation authorities, sometimes lease the rentals. So deposits also is one more asset. So likewise, if you take the measure of the assets, you will find that suppose let us take the example of loans and advances. Okay, so in the loans and advances, as a valuer, you want to evaluate what will be the value of such loans and advances. For that, again, you need to have a data that the documents pertaining to loan, what are the terms and conditions of that loan given to a particular entity. Okay, then thereafter you have to check that whether that entity to which the loan has been given, they have acknowledged the debt, because many times we find that the loan is being shown as given, but whereas the other party has not given any confirmation. So that also happens. So in such cases, you have to check that whether that loan has been confirmed, whether there are if it is pending for more than year, then in that case, if any legal action has been taken or not taken, many times litigations are in place. So in that case, you have to go through the documents pertaining to such litigations and the stage at which it is. So in that case, again, you have to approach the IP and get this document, and based on such documents and evidence, you will be in a position to identify and come to the realistic value of that particular asset. So here the important point again is that the documentations which perhaps the IP is having, which has been shared with the IP by the CD. So based on such documents, this you will be in a position to evaluate such value, fair value and liquidation value. Coming to the other categories like trade receivables. So in that case, it's very important to know that who are the parties, their aging, whether there are any acknowledgement of the dates, whether any confirmations are sought, whether such confirmations with responded with, if there are pending litigations, so that also is remains a question mark. Many times there are defective supply of goods or supply of services. So in such cases, there also could be a dispute between two parties. So here also we have to look into the aspects of law like Limitation Act. Okay, for example, a debtor is remaining outstanding for more than 3 years, and there is no action has been taken. So in that case, perhaps you have to also look at that perspective and ask the resolution professional that have any CD has taken any action with respect to the recovery of such debts. If it has taken, then perhaps you will be in a position to evaluate and assign some value. So if there is no action taken, in that case, the legality of recovery, so that becomes a challenge. Even though you may uh, sometimes it happens that in the good faith we say that okay, this party perhaps is ready to pay, but if the limitation period has already been over, so in that case you have to also check into the legal aspects that whether subsequently will it be possible to recover such dues in next course of time. So, in my opinion, as a registered valuer, the first and foremost things I would like from the IP is that the whatever documentation available should be provided, and these documents need not to be only with respect to, like we said, that the communications between the data. Sometimes it happens that okay, there are communications, but the entity from which the money is to be received, that entity itself is under insolvency. Okay, so in that case, we are we get some feeling that okay, in such cases, whether it will be possible to recover the debts. So that information is also critical. So we have to have not only the information from the IP, but we have to gather it also from the different public sources from which such information we can get it. One more challenge, rather, I find when we are doing a valuation, that is with respect to the unlisted shares. Okay, so what happens is that a company may have investment under current investment, they may have shares of some companies. Okay, then that shares of company you want to value such value this unlisted shares. So in that case, you have to have the books of accounts or the financials or any kind of information which will allow you to get a value out of it, that you have to get it. So for that again you have to go one step down and ask the IP to get such details. Then I have been a part of the case wherein I have to go 3 stages down. Okay, because that company again was holding some shares of another company. So there are 3 layers like that. We have to dig it out only for uh, uh, one asset. I will call that as a current investment in a particular private limited company. So this information sometimes it happens that we while taking the assignment, we feel that it's that way simpler. But you have to unfold this all the layers, and then actually you come to the real part, and there where I find that there is a lot of expectations from the IP to help the valuer to get the information. Actually, IP is the one professional who has got I will put it this way, since he's handling the matter, he has got a good command over the CD. Okay, So he might give some of the important informations and aspects which perhaps could be critical for doing the exercise for the validation of the CD. So this informations and I think one more point I would definitely like to bring to notice is that in the asset side you will find the asset like inventory. You know, that is a very subjective thing, and many times the challenges are also different. So I was a part of one assignment wherein there was a huge stock of steel. Okay, there was no electricity in the factory. There was no weighing machine available. So, and so the question, the problem is that how you count, because you don't have a labor, you don't have equipments which will allow you to at least have a weight of that particular steel. Okay, so in that case, it is expected that the IP, rather as a valuer, will expect that some arrangements which perhaps are critical for completing this valuation exercise should be made available to the registered value. And this perhaps I think uh, of course the IP also would be facing that problem. So I feel that these such problems can be put up to the COC, and whatever the necessary help that is required in terms of getting the resources or channelizing some help, that can be initiated by the insolvency professional. So that will really help the not only the valuer to complete the exercise, but that also will give a fair chance to insolvency professional to give a right perspective or right facts to the notice of the resolution applicants as well as the COC member. Ultimately, the objective is to resolve under IBC. So this perhaps having the fair and correct valuation exercise will enable to have a good amicable solution. Otherwise, many times it also happens that valuations are when the plans are getting approved, then later on there are some certain litigations
Sir,
because
sorry to interrupt. Is it possible to be beforehand go and check and then quote for the assignment? Because if you want to take such inventories into stock
sir, you can ask sir.
At your cost, it is not economical. No?
Sir, you can ask so. I mean, if you are not sure about the what is the quantum of work, it is always advisable to do a first visit to the such this thing and assess the quantum of the work and quote accordingly. So you can very well do a site visit before you take up the valuation assignment. So
Okay.
this inventory, so this is one more thing I would like to definitely have, as a valuer, I will need some more support from the side of the insolvency professional and also from the COC. So then I think one good provision that has come up recently is that the valuer will be given a chance or he has to present his valuation to the COC. So perhaps that will enable now the COC to cross question the valuer, and many times it is also very good that some aspects can emerge out of the discussions which will enable the valuer to get some more information and get some more realistic valuation in place. So in fact I was also part of such presentation, and during the course of presentation, so we told that some of the documents are not available with the IP. So that is why we are not in a position to give or assign any value to a particular set of assets. So in that case, one of the COC members helped us. He said that some of the documents are available with our office in the form of there are certain stock audit reports which were available. So which otherwise were not made available now because of that interaction between the COC and valuer. So that allowed us the opportunity to gain some more documents, which enabled us to give a even better accurate valuation to the COC. So I think this is a welcome move by IBPA, and this also will bring some more responsibility to valuers to explain the valuation methodology. And if whatever these assumptions and certain things perhaps he has mentioned in the report, it can get better clarified by way of interaction. So I think that will help us in a better way. And of course, we can also share our difficulties, what we have faced when we are doing the valuation during such discussions. So some ways can emerge, and some solutions can be uh, uh, come when we discuss such things. So that will allow us one more opportunity. I think, and one more expectation, of course, the valuer always has is that he has to realize that, the IP should pay his fee on time. Okay, whatever is being decided has to be paid on time. So that is somewhere, IBBI also has trying to ensure that this thing. So likewise, the CRP cost has been now more or less settled on by IBBI. So similarly, valuation for valuer fees, some, at least some provisioning is being made under CRP cost. So which will, have a better confidence of the valuers, because I think I will take this opportunity because Shankar sir is there. So, there are so many valuers, but when it comes to IBC valuations, only few valuers are doing the IBC valuations. The reason is that many of the people are not doing. The reason is that they don't get paid on time, they don't have data. Then they are subject to so much of, questions and answers by COC, by RP. There are a number of iterations and versions of the valuation reports, and ultimately doing that also is subject to all, is carrying a risk. So perhaps that is not reflecting in the valuation rules. We have nicely written that the fees of the valuer are the reflection of his work. But unfortunately, in IBC cases, sir, it is not properly reflecting what the work has been done. And so somewhere, you have to think about that portion also. So I think so. These are the few, my experience sharing. I will put it this way than the expectations, and I'm sure that as the we are maturing this whole IBC mechanism. So days to come, you will have we will have better and settled uh, settled system, so which will allow us to do work more efficiently and more diligently. So thank you very much, Dr. Gupta.
Thank you, sir. Thank you, sir. Thank you.
So thank you so much, Harshad sir, for such a nice session, sir. It was a very informative session. So thank you so much. And now moving forward, let's call upon our next speaker, Mr. Sandeep Goyalji, and our topic would be on how to interact with the RB on key aspects of valuation. So I welcome Mr. Sandeep Goyal sir. Welcome sir to this session.
Thank you. Thank
Thank
you.
you so
Thank
much,
you,
sir.
Gupta ji,
So
for
you may just
inviting
start
me.
your session, sir. Thank you so much.
Yeah, thank you, Gupta ji, for inviting me for this session. Thank you. And good afternoon to all, and including Mr. Arshad Deshpande and Shankar sir. Actually, I've been given a topic that how to interact with registered valuer or key aspects of valuation. I think the interaction of the IP, I am an insolvency professional practicing as an insolvency professional. Our first interaction with the valuer start with asking the quotation and then submitting this declaration that they have no connection with the company. There are certain qualifications, this qualification has been given. So that qualification certificate we start with, and then the appointments is confirmed. And then what valuers is requiring from that IP, how to submit a report. So far we have discussed that what is the importance of this valuation report and how a company can be liquidated if the valuation is not correct, and a bad company can not be survived because of the just for the valuations. So importance is there. So we have to gather the many informations, and RP has to support as much as possible. Suppose there are three types of valuation we have to do the report. Valuers we have to appoint, that is the plant and machinery, and the land and building, and securities and financial assets. So all the three people are there, I think, in this session. All the three kind of people are here in this session, joining this session, or only financial assets?
I have SFA, sir. I am from SFA.
Acha. Any other land and building plant and machinery is also joining, Gupta ji? All are from SFA only.
Mostly are the securities and financial assets.
Securities and financial assets.
Yes,
Okay. Mostly are there. So you know that under IBC we have to go through the three types of report. All the valuation is to be done by the registered valuers, and information and the information required and to be shared will depend upon that how to interact. So RP and valuer has to work hand in hand, because RP also faces a lot of challenges while getting the information. And whatever, because we have to do the valuation as on the CRP date. And so many times it has been noticed that CRP date balance sheet is supposed to be provided by the ex management to the RP. But mostly, not only one case, I think most of the cases, this information is not available. If the company is not going concern, and I am appointed as a RP, and I have to get the valuation done and provide the information to the valuer. And because mostly here, as you said, that is a valuer of SFA, so this problems comes in, because other classes you can visit the plant, have the inventory done, plant and machinery, and can value based upon the assets. But the real challenges comes when the data is not available and we have to do the SFA valuations, because it is a duty of the RP to provide you the details of the assets, the current assets, their inventories, details, all the data I have to, as a RP, we have to provide you. And you can ask from the IP all the details, that memorandum association, article association, annual report of past 3 years, audited provisional financial statement as on CRP and date, brief profile of the company, past project report, valuation report, TV report, whatever is there. Secretarial compliances document including ROC charge form, because you have to see that whose charge is there on this particular thing. Any sanction letter on mortgage deed for loan taken by the company, financial projection, business plan carried out by the third party agencies, information about the special benefit, exempted tax, subsidies applicable to the company. So these documents are required, and RP has to ensure that accurate data may be given, because valuer may write in the disclaimer that whatever the report has been submitted, that is submitted because based upon the document provided by the IP. So very important is that when you interact with the registered valuer, to be ensure the accuracy of the data. It's a two-way process. I think we valuer, as I told you, is not complementary to each other. So our objective should remain a common, whether I'm an insolvency professional or you be a registered valuer, that to find out the closest value. Two kinds of valuations are given under IBC. That is, the one is the liquidation value and other is the fair value. Liquidation value, as you know, the minimum price which the company will fetch in case of being liquidated as on the CRP date. In a distress condition में अगर उसको बेचा जाएगा, then what will be the price? And fair value normal circumstances में what it can be fetched. So we have to arrive these two valuation, and importance become, because in practicality, I think you all might have noticed in the balance sheet there is a number of debtors are there, and numbers of investments are current assets are there. But we have to verify from the, as a RP, I think we have to provide this information, how much maybe the aging of the debtors is there, and what are the likely chances, what are the documents RP is having to recover those debtors. Generally, it has been noticed that these debtors are being carried forward since long, because generally you know that any company is having limits with the various bankers, and these are the current assets on which the limits are there. Before the account goes into the NPA, people do try to manage these debtors through the debtors and investments in the books, current assets to maintain that limit. So generally it has been noticed that no records are there and no efforts are being made by the ex-management to recover those debtors. And they are the old ages, the old debtors being carried forward. So we have to be very careful while valuing these debtors and creditors and looking at the aging documents and all. So RP has to try and provide as much as accurate information to the valuer, because RP may be having a wider reach of the data and the information which valuers may not be there. So while interacting the key aspect, because the report of the valuer will depend upon the whatever the data he has got. So as much as accurate data, because RP2 have the limitation that we have to understand what information it can provide so that accurate valuation can be done. So far SFA data is concerned, RP do make their own efforts in getting the data from the ex-management and do provide to the closest thing whatever is available to him, and based upon that the valuation can be submitted. And so long this plant and machinery and land and building valuations are there. Generally, these are this land and buildings are being mortgaged with the secured financial character. So property documents can be obtained from the secured financial character, even while granting the loan, and thereafter also bank do get the valuation report done. So now there is a recent discussion paper and amendment by the IBPI that whatever the data is given to the valuation report, that may be shared with the RP. So whatever the RP is getting this information about the valuation, the previous data, so they must share, I believe, to the valuers, so that whatever the best information he has can give it to the valuers, so that valuers can arrive to the valuation. Because we do write as a valuer disclaimer that based upon the data and all, you have submitted the report, but it doesn't mean that we should not make an effort to get, as our Mr. Deshpande told, that to obtain the information from the secondary sources also. So like we can verify the charge from the ROC. So ROC website, the public domain data is there. We get the paper for the charge, that is good. The charge is satisfied or not satisfied, you can do that. So all kind of efforts we can do apart from the balance sheet thing, then while giving the valuations. So as much as we can do, we can do. Vishnu ji keh rahe the, we don't generally do verify from the this debtors, generally letters. As a RP, do we send these letters to the debtors and take confirmation? But generally, we do say to the valuer also, if you want to have a confirmation from the party and debtors, you can have your independent check also, apart from the data and the check, whatever RP has done. We do provide to these valuers. And if they wish, they can do it. If they don't wish, they don't do it, and then they can submit. It's not an obligatory on the part of the valuer. But to arrive at the accurate valuation, if they also wanted to do and to have their backing paper also of the report, they can do that, but not necessarily mandate upon the valuers. But it is definitely mandated upon the insolvency provision. So like the capital work in progress may be there in the company. So many details is required. Progress status as on date of valuation, supporting document like contract copy, invoices, purchase order, etc. Detailed specification like make, model number, capacity, material or construction, etc. for high valued assets. You know, the capital work in progress may various type of equipments are also being purchased of big value, maybe ranging to the several of crores. So suppose if the data in machinery may be imported or indigenous also, if the make is available with the RP or some file purchase registered is available with the RP, so then this detail may be there. So suppose if sometime we have noticed that even capital goods are being imported and that is lying at the factory premises, not yet even installed at. So that is totally new kind of a machinery. So that valuation will affect. Naturally, you can give the higher value to this kind of thing. So if the previous price and everything is available, and then you can, it will be easy for you to value that thing. Payment terms as per defined milestone and the contract and CWIP, because you have to ensure payment भी हुआ है कि नहीं हुआ है, machinery may be lying there. In certain cases, as I told you that the records are not there, then how to ascertain we found that some machineries are there in the plant, but payment has not been done. So that also to be verified, because we are valuing the asset of the CD, not the asset of the third party. There are then intangible assets are there, brand, trademark, goodwill, customer relationship, patents, generally from intangible assets. Depending upon the nature of asset, the following list and nature of detailed description of the intangibles, potential projected cash flow associated with intangibles, any other details deemed necessary may be obtained from the RP, so that he can provide you whatever the best is available to him. So you can value. Then the valuation comes of the non-current investment in securities, mutual funds, investment in subsidiary, associate company, joint venture, generally from other non-current investments. Then what kind of details to be shared and interaction may be given, the nature of details and certificate of investment, type of, in case of investment is made of any other entity, details of any investee company with the latest audited provisional financial statement, financial position of the investee company, any other details deemed necessary may be given to registered valuer. Then come the deferred tax assets into the balance sheet. We are valuing the SFA, then it's a very important aspect. Copy of income tax return along with computation of the last 3 financial years. We can discuss and give it to valuers. Working out deferred tax assets, liability, ledger of DTA, DTL on the valuation date may be given. These details may be made available by the RP, and RP do generally get, because he is able to assess through the income tax portal and other thing also. So certain details can be fetched. If it is not available with the X management, then we do try to get this information and do provide it to the valuers. And you know that this is a time-bound process. The valuation report is also now T plus 90 days is to be submitted. And 135th day the plan comes in, then before at the time of negotiation of the plan, when the COC is in discussion, then RP has to disclose the fair value and the liquidation value by taking undertaking. So now it has become mandatory, done by that within T plus 90 days the report to be submitted. So RP2 has to gather the information as fast as possible. Practically, I've seen in certain cases takes some time because most of the information what is required to submit to the valuer is not even available with the RP. So still we have to work in hand and get the best thing whatever is possible and do the thing. RP and valuer must work as a team. And most of the cases, I think we work in a dual phases, that we are one cases we are an insolvency professional, other cases we are a IP also. Insolvency I have registered valuer also. So we understand both the end, the challenges and all. So then we work very discreetly that how to arrive at this situation. So this thing is always remaining in that. Then current assets, we have already discussed that aging of the assets should be there, provision created if any, reason for long due balances, details of disputes along with current status of the matter, legal opinion, outcome of the appeal of the recovery, amount, management comments, etc. may be shared with the valuers. Details of inventory lying at premises of third party along with aging analysis, balance confirmation, any other details deemed necessary may be given to registered valuer. Then comes the balance sheet item is the cash and cash equivalents. The following details are sought for the cash and cash equivalent, nature of the balances, bank statement along with bank confirmation, bank reconciliation statement. You can ask from the IP, this he can be provided to you. Then he will provide you the cash certificate if the cash is there. So based upon the cash certificate, suppose the RP has received the cash from the X management, then he will provide whatever he has received. Suppose the balance sheet is showing cash worth 20 lakh or 50 lakh and RP is not received. So you will not be able to give the valuation to that amount because RP is not received. So because you have to give the valuation on the CRP date. So whatever is available. So you can seek from the RP that you can provide you the cash certificate. If the cash certificate is given by the RP, then you can safely assume the same value of that amount. Otherwise, you will make it as a zero. Whatever be the balance sheet value may be there. Details of any lien, any other details may be necessary, may be given in this connection to valuers. Then come other current assets into the balance sheet, loans and advances, deposits, balances with revenue authorities, claims, advance tax generally from other current assets. Depending upon the nature of the asset, the following details are generally may be given to valuers, detailed breakup of the assets and aging analysis, expected date of realization, comments on recoverability of the receivables, copy of ledgers, balance confirmation from the parties. If the receivables is under litigation, current status, legal opinion, outcome of the appeal, recovery amount, management comment, etc. may be given to the valuers. Then in the balance sheet, you will see that contingent liability is also there. So we have to give the comments as a valuer on the contingent liabilities aspect also. So list of contingent and liability along with its nature, details, legal opinion, current status, and management comments. Other details deemed necessary may be given to valuers. So because valuer can straight away write that whatever the information has been given, the valuation is based upon the same. So now role of RP become very important, that as much as accurate data as on the CRP date he has with him to provide to the valuers, so that valuers can arrive to the right valuation of the current assets, SFNA valuation particularly I have seen. Second, plant and machinery. So you can suppose if the accurate data is not available, even then you can go to the plant and have a factory visit, list out the machineries, whatever are available as on the date. So even RP will confirm you, okay, this is a CRP date and he has received this many. Sometimes we do the panchnama. Suppose the record is not available as a RP, when we take the charge, we do the panchnama and may list out the machineries what was available. In some cases, we do find the fixed asset registered. In some cases, fixed asset registered is not there. So then it is not there, then how to value it? Then we do provide make the panchnama and get it signed by the ex-management also. And we do provide it to the valuer. So valuer knows that these are the machineries was there on the CRP date. And when he visit, he ensured, okay, these machineries are there or not. Because when you are valuing, suppose if something is written into the panchnama, it is not there, then you have to point out to the RP that this is not there. Or some certain time, generally I am not seeing it is not there, it is there always. Certain small item, generally we do to go there when take charge. Being a RP, we may not be able to identify all the assets. So sometimes we club it together. You being a particular expert into the area, then you segregate this thing, then I've seen that number of items increases. Then you give the valuation to the number of plant and machinery according to that. And suppose if the register is there or the invoices are available, even if we obtain from the financial creditor and other thing, that because certain time when the loan is taken from the banks and all, so original bills are being submitted to the banks also. So we do try and fetch these detail if it is not available with the corporate data from the financial creditor, and then do to provide to the valuers. And we do give the copy from by taking from the bankers and all. And even in our cases, I have arranged the visit of the, suppose the plant premises there, the particular case is there, the banker also visit you can have, and have access to the past valuation report and data from written there, or other things, so that you know what was there, and accordingly you can give the report, the current report. As on date, the valuation should be accurate, because in certain cases you may find that valuation was overvalued while taking the loan. So there is no punishment even if you give the lower value today, because you have to be realistic today. There is no question ki asked by the any valuer कि भाई उस समय रिपोर्ट मशीनरी की मान लीजिए 100 करोड़ बताई गई थी, आज ये 20 करोड़ क्यों है? Because you know that what is the current market can be sold and what can fetch, or even if you install a new machinery, then what is the replacement cost of these machineries today? So that accordingly you can give that valuation. Now, what are your practical experience? You people are also doing lot many valuation. What kind of challenges you have faced? Because this is basically an interactive session. So I will like to listen from you and then answer you that what are the problems you have faced and how to handle that. Any question?
Any participants having any query or questions, so you may just ask or discuss.
Otherwise, I'll continue, because I think it's an interactive, so it will be more beneficial if you.
Right, sir.
Whatever the practically you might face, as I told you that practically when I got the valuation done, what kind of challenges I have faced as an insolvency professional, that in certain cases there was no data available with me at all. Then even then we have to get the valuation done, and securities and financial asset, the balance sheet, last balance sheet filed with the ROC record was also not available. That was prior to 3 years old. So details of the debtors and creditors was not available. That was a major issue. So definitely there was a huge sum was appearing to the balance sheet, but we could not take that balances to the valuation. because it's a more than 3 years old debtor, and no records is available with the RP to recover those debtors and all. We, as much as data we could retrieve from the public domain about the name of the companies and all, we returned to them the letter. And in one case, I'll appreciate that certain recoveries was also made from the data. These were the PSUs organization. They asked us certain details and all, but we said and sent the letter and all. There was a small amount, but we were not having the much detail, but that has been done. So certain recoveries are always possible if that is a genuine deal in these data cases. So you may assign these valuation according to that, whatever the confirmation is being given by the valuer, the RPs and all. So practically, so many information RP need to provide you. Definitely, you will ask. You may be having a long list, as I discussed with you, that you can ask all this information from the RP, and RP is supposed to provide you the entire detail. But challenge before is RP remain, and you can start with the memorandum of association, article of association, annual report, brief profile of the company. Definitely, you'll ask for past project report if it is there, valuation report if it is there, TB report if it is there, you can ask for sanction letter and mortgage deed of the loan taken from the company, you can ask for financial projections, you can ask for whatever the RP may be having, you can provide you. Land and building mein kya hai, then land and building plant and machinery documents may be there, figures register may be there, clarity about original revaluation number captured in figures register, you may seek from report on physical location, verification, mapping of asset and figure register, summary of land area with details about type of ownership, area, unit of measurements, etc. The whatever is there, you can ask for. So all this thing may be there, and I think my time is getting over. I can. Gupta ji.
Sir, time is as per the schedule. Time is
Yeah, time is getting over.
right,
So
sir.
I think there is no question. So I'll
Sure, sir.
complete it here and can continue, please. Thank you.
Sure, sir. Thank you so much, Sandeep sir, for such a nice session, sir. Thank you so much. And thanks to all participants. So now moving forward, our next topic is how to read the valuation report and how to present the valuation report before COC. And now once again, I would like to call our speaker, Mr. Vishnu Upadhyay, sir, for this topic. So you may just
Thank you.
start your session. Sure,
Thank
sir.
you, sir. Thank you for inviting me again for the next session. So this topic is how to read the report by a resolution professional or liquidator. Once the report is with him, that he has to review the report, that the report is complete or not. Like there are different parts of the report as per the scope of work and the reporting standards. So the resolution professional has to ensure by reading the report that this is a complete report from the registered valuer. So it starts from the identity of the valuer. So the identity of the valuer must be captured in the report, that who has prepared this report, what is his address, email ID, and if phone number is not there, that is okay. But email ID and the address, postal address must be there. And about his qualification, his registration number, IBBA registration number, all those things must be there in the report. And next part comes the identity of the corporate debtor, the profile of the corporate debtor, that what is the business of the corporate debtor, when it is incorporated, what is the status at the MCA website, that also capture many things about the corporate debtor. So at least a brief profile of the corporate debtor and the appointing authority. So in this case, there may be the possibility that IRP has appointed and RP is different from the IRP. So the appointing person must be the detail of the appointing person, date, all those things must be there in the report. Then comes the valuation date. So for the CRP matters, we all know the insolvency commencement date is the valuation date as per the IBC regime. So that must be also incorporated in the report, valuation report. And the inspection of the assets, date of inspection of the assets. So that also must be the part of the report, and it is captured. That has to be seen by the insolvency professional in the report. So when the inspection is being carried out by the registered valuer, there must be a team of the RP or the corporate debtor. So those details also need to be incorporated in the report, that who has accompanied from the side of the corporate debtor and the resolution professional uh, at the time of inspection to get inspected the assets, tangible assets at the site. So his name, his or her name or designation, and the mobile number or the email ID. If mobile number is not given, because that comes under in the personal detail, so email ID must be there of that person who has accompanied at the time of, who has given the support or coordination from the team of the RP and the corporate debtor. Once these details are there, then the date of the report submission, when the report is submitted, that also must be there in the report. Then the definitions, different definitions of the terminology, like the fair value, liquidation value, that also should be the part of the report. And then comes the approaches, different approaches, a brief of the all the approaches definition, and the method adopted for the purpose of determining the value, that also need to be explained in the report. Then we comes at that what all the assets need to be valued. That must be there, a list of the assets which need to be valued by the valuer as per his or her scope in the report. Then comes we need to read in a manner that the what is the methodology being adopted by the registered valuer to determine the value as per the regulation. So that methodology must be there in the in the report, and what the requisite data has been asked and provided by the resolution professional, that must be there in the report, and the resolution professional can see that all the data which he has provided is been mentioned in the report or not, which was relevant for the purpose of valuation. So there may be some possibility, sometimes some irrelevant data also the resolution professional provide to the registered valuer. Like I give an example, suppose the registered valuer is for the category of SFA, then the property detail also provided to the valuer of SFA. Sometimes the resolution professional deal with all the valuers in a single mail. So the resolution professional provide all the details to all the valuers. So irrelevant data can be ignored, but whatever is the relevant for the purpose of the asset class, which is being handled by the registered valuer, that must be the part of the report. Then we come to the individual assets, that what the method is being adopted for the purpose of valuation, that must be their part of the report and the valuation report. And the detail must be there in the annexure, that how it has been determined, and the name of the assets, maybe some description of the assets, like in case of the land and building and plant and machinery, a brief description also required, like Sandeep ji has told that make and the capacity also may be mentioned in the report, like what is the capacity and what is the make of the machine, so that the person who is reading the report can understand the value which is being determined against the assets is appropriate or not. when the resolution professional is reading the report, he must see, he or she must see that what methodology is being adopted for each and individual assets, like the basis of value. We know the basis of value is the liquidation value and the fair value, but the before the deciding on the this basis of value, which is mandatorily we need to provide the fair value and liquidation value. For that purpose, there are four premises are there. First two premises are for the purpose of fair value, and last two premises are for the purpose of liquidation value. So here, when we determine the fair value as a going concern, so there may be the possibility that being a valuer, we cannot consider the highest and best use of the assets. So we have to choose the premise as a existing and current use. And for the purpose of liquidation value, we have to consider the forced sale, because there is not enough time to sell the assets, because the liquidation is date is being assumed is the insolvency this sorry ICD, insolvency commencement date. So that is there. So there is no time, reasonable time to do the marketing and all. So we have to consider the forced sale premise. So the premise also need to be mentioned in the report that what premise we have considered for the purpose of different basis of value. Then each assets which are valued, the what method is being adopted, that also must be the part of the report. Then the conclusion comes that this is the fair value of all the assets which is there in the report, and this is the liquidation value. And assumptions, if any specific assumption is being considered for any specific assets, that also must be there with the each and individual assets where we have assumed any specific assumption. And then all the assumptions which are ordinary assumptions must be the part of the report. Any limitation is by the valuer is being considered, that also must be there in the report. Any caveat, which must be, all these limitations, caveat, assumptions must be within the guidelines of the IBBI, which are already there. It's been prescribed or issued by the IBBI. So those assumption and limitations or caveat must be in line with those guidelines. Then the conclusion has been there. Then those annexures must be the part of the report, which also helpful to understand by the resolution professional. Like in the report, main report, we may provide some summary kind of thing, but in annexure we have to provide in detail, because later on there may be possibility that corporate debtors resolution plan is not approved. There may be failure of the plan. So in that case, the corporate debtor will be in the liquidation, and in the liquidation there may be possibility that the liquidator may need to sell the assets, each and individual assets separately, or maybe like as per regulation 32 of the liquidation regulation. There are different, there may be parcel of these different assets, few assets, and standalone assets basis. So those in those situations, the individual value of each and every assets are required by the liquidator. So those details must be the part of the report. Then comes to the presentation in front of the COC. I have been the part of the presentation team in few cases where about more than 20 bankers were there as a consortium. So when we are presenting the report in front of the COC, we can make a few 5-6 slides that this is the summary of all the assets is being valued, fair value and liquidation value. And then the next sheet, we can provide the detail of each asset class, like land and building, plant and machinery, and SFA, the fair value and liquidation value. And later on, for each asset class, we can provide the detailed, not complete detail, but a summary for each and every assets. Like for what is the value of the land? If there are more than one land, then land situated at that location is value is this much, and situated at different another location, second location, third location. So location wise also we can provide we must provide the detail of the valuation. Likewise, for the plant and machinery, we can provide with the different asset category in the plant and machinery, like equipment, plant and equipment, furniture, fixtures, vehicles, computers. Likewise, we can provide a summary details in a slide. And if required, we can share the detailed annexure which we may have in the Excel also, if the COC asks the further detail. Then we come to the SFA category. So there are number of assets in the SFA category, like the plant and machinery. Maybe 5, 6, minimum 4, 5 or 6 assets are there. It may go up to the 10, 12 assets category within the SFA, like investment, deferred tax, and deposits in the long-term assets, and in the current assets, the inventory, investment, trade receivables, bank balances other than the normal bank balances like deposit, fixed deposits, etc., and the advance and loans and advances and other current assets. So those asset, that summary must be provided. If further detail is needed by the COC, we can refer the detailed working sheet when we are presenting to the COC all these information. So this is on the subject, the reading the report and the presentation to the COC from my side. But here by submission, earlier it was not there in the guidelines. So it is now, it has been made part of the presentation in the scope of the valuer. So the consideration when we are quoting for the purpose of valuation, we must incorporate the fees, including the presentation to the COC, or we may put in that a separate line item that it is excluding in presentation to the COC. If we need to present to the COC, this may the cost to the corporate debtor for the purpose of valuation. So this is on that part, reading the report and presentation to the COC. If any query, we can take those queries, or if anyone want to share his experience, his or her experience on this topic or any other topic. So there are different faculties available, and it is an interactive session. We can take those all those queries here. Gupta sir, or Suman sir. Anyone is from RBO? It is over to
Yes,
RBO now.
sure, sir. So we are if we are not any having any query or question, so we can just conclude this session, sir. Any participants having any query or question, so you may just ask.
Here, I would like to share one thing from my side, sir. When we are doing the valuation of all three asset class separately, like land and building, plant and machinery, and SFA category, we the valuation of the business is not included in these valuation which we are doing separately. So in some of these assignments, I used to interact with the RP. Please have the enterprise valuation of the corporate debtor. So in some of the situation, I have done the enterprise valuation also, which fetch the business value of the corporate debtor. So this is my like opinion on the part of valuation.
So thank you so much, Vishnu sir, for such a interactive and nice session, sir. Thank you very much once again. And also, I thanks all the participants for joining this session at ICMAI RVO. So with this, we have completed our today's session. So if we are not having any query or questions, so we can just conclude this session over here. And I thanks once again to all the participants for joining this session at ICMAI RVO. Thank you so
Thank you.
much,
Thank
Vishnu
you.
sir, and thanks all our speakers. Thank you so much to all. Now we can just conclude the session over here. Thank you so much.
Thank you, sir. Thank you.
Thank you, sir.
Thank you, everyone.